The committee, our time is up.
Presenting their submissions before the National Assembly Education Committee, the Office of the Director of Public Prosecutions presented a list of 53 exam malpractice cases from the period of 2019 to 2022, adding that the common offence is possession of unauthorized exam materials.
But I would rather we take that on a case-to-case basis.
However, 46 cases out of the 53 are yet to be concluded, with most charges befalling on accused persons being 1 year imprisonment or a 300,000 fine. And on the question of KNEC and parents not being accountable for examination cheating.
But there is an issue of also them being covered up by their institutions because they do not want to show that it is KNEC that has given out this examination. Schools also cover up their officials because they don't want to be blamed. Unless these people are targeted from the beginning by the investigators, it is very difficult for us as the DPP to say, go and pick these parents because they are the ones who gave this child the papers.
The DPP then proposed the introduction of ancillary orders.
Officers who compromise examinations, schools, and even examiners, invigilators, they should be barred, for example. An example of an ancillary order. Barred from administering examinations for 5 years or barred from teaching.
And on the question of prolonged completion of cases,
we could propose that this committee could initiate some legislation where you provide a limited time for the prosecution of those particular cases. But I think in the wisdom of the committee, you can look at within the year, probably, within the year that the exam is done.
And in most cases, and we can show data, most cases that we withdraw are cases that we have looked for the witnesses many times until we are given notice by the judiciary that if we cannot proceed, then we have to withdraw.
To curb examination cheating, DPP made several recommendations, including adopting a multi-agency approach in handling of examinations, increased budgetary allocation for capacity building and proper infrastructure for exam setting, community sensitization on ethical values, proper and timely data capture for recorded cases of exam cheating.
We had the DCI and the police complaining a lot that every other time they present a watertight case before you, all their cases fall flat.
So where they feel that they bring a watertight case, according to them, their work is to collect facts. Their work is not to say whether a case is watertight or not. If the law has given us the mandate to say whether or not a case is prosecutable or not, we will carry up that mandate.
The judiciary is expected in 7 days to present the total number of exam malpractice cases in 49 courts after presenting only 25 of them that were gathered from 87 courts. Harriet Chimea, K24.